Florida wage theft. Small claims court versus federal DOL. What's faster? Florida has no state Department of Labor. Unlike California or New York, workers here cannot file a wage claim with a state agency. Your two paths are the U.S. Department of Labor's Wage and Hour Division or a direct lawsuit in small claims court. As stated on the official website of the U.S. Department of Labor, DOL.gov, the WHD investigates violations nationwide. Why Florida has no state DOL? The enforcement gap explained. Florida is one of the few states without a dedicated Department of Labor that accepts wage theft complaints. The Florida Department of Commerce handles unemployment only. It cannot investigate wage claims. Florida does have a state minimum wage of $12 per hour as of 2025, under Amendment 2 passed by voters in 2020, but enforcement relies entirely on private lawsuits. As set forth in Article X, Section 24 of the Florida Constitution, you can sue for unpaid minimum wages, but there is no administrative shortcut. Path 1. File with the federal DOL, the Wage and Hour Division. WHD investigates FLSA violations for free. No lawyer needed. Call 1-866-624-US-WAGE or visit a Florida WHD office in Miami, Orlando, Tampa, or Jacksonville. File online at dol.gov/agencies/ITD/contact. The process is confidential. The WHD interviews witnesses, inspects records, and calculates back wages. Typical timeline, 3 to 9 months. If the employer refuses to pay, the WHD can sue on your behalf in federal court. Path 2. File in Florida Small Claims Court. You can sue your employer directly for unpaid wages without a lawyer. The limit is $8,000 under Florida Small Claims Rule 7.U10. Filing fees are $55 to $300. Indigent waivers are available. After filing, the employer has 20 days to respond. A pretrial conference is held within 30 to 60 days. Most cases reach trial in 60 to 120 days. Side-by-side comparison. WHD versus Small Claims Court. On speed, the WHD takes 3 to 9 months. Small claims reaches trial in 60 to 120 days, generally faster. On cost, the WHD is free. Small claims has filing fees of $55 to $300. On recovery, the WHD has no dollar cap. Small claims is capped at $8,000. On lawyer requirement, neither path requires a lawyer. Before you file, document everything. Wage theft cases are won on evidence. Start a daily time log. Save every pay stub. Under FLSA Section 11(c), employers must keep records for 3 years. If records are missing, courts rely on your estimates under Anderson versus Mount Clemens Pottery from 1946. Preserve screenshots, emails, and texts about pay. Back up to cloud storage, not your work computer. Retaliation is illegal. Under FLSA Section 15(a)(3), it is unlawful to fire or discriminate against an employee who files a wage complaint. The Supreme Court in Caston versus St. Gobain in 2011 held that oral complaints are also protected. Florida's Whistleblower Act, Florida Statute Section 448.102, also protects you. The Florida Constitution Article X, Section 24(c), explicitly prohibits retaliation for wage complaints. When to go to federal court? For claims over $8,000 or for double damages, file in federal court under FLSA Section 16(b). You can recover unpaid wages plus liquidated damages, double your stolen wages, plus attorney's fees. Collective actions let multiple employees join one case. The Supreme Court in Tyson Foods versus Buafacchio confirmed that representative evidence can be used. Your action plan? Under $8,000 with clear facts? File in small claims court yourself. Over $8,000? File with the WHD first. Multiple coworkers affected? Hire an FLSA attorney for a collective action. Step 1. Build your evidence file. Step 2. Choose your path and file. For the WHD, call 1-866-4-US-WAGE. For small claims, visit your county clerk. The law is on your side. Start today.